Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. Enforcement action heats up as the administration takes its DEI fight to employers on multiple fronts. In 2025, the Department of Justice launched its Civil Rights Fraud Initiative to investigate employers who contract with the federal government based on the theory that their DEI practices could violate the False Claims Act.
The False Claims Act allows the government or a private whistleblower acting on the government's behalf to sue an entity that knowingly submits a false or fraudulent claim for payment to the federal government. So here, DOJ's theory was that federal contractors must certify that they'll comply with the anti-discrimination laws as a condition of their contracts.
The government claims that contractors who make this certification while engaging in DEI practices are violating the Act. Employers found to be in violation of the FCA face treble damages that can easily stretch into the millions. Federal contractors should also be aware of the recent executive order requiring them to certify that both the contractors themselves and any subcontractors will not engage in discriminatory DEI practices. Action to comply must be taken by April 25th.
I think it's a real wake-up call for federal contractors and grantees. The Civil Division, coincidentally, my old division at the Department of Justice, and the EEOC, through Chair Lucas, have all publicly signaled that they will aggressively pursue investigations of Title VII and other violation of statutory laws. And there's real liability exposure for employers here. So this is more than just front page news, but for employers and employees, this will have real life consequences.
Private employers should be watching closely too. The risk right now isn't a single court ruling declaring DEI unlawful, it's enforcement, investigations, subpoenas, and contract obligations hitting from multiple directions, often before litigation even begins. Finally, it's important to note that the practices at issue, diverse interview slates, diverse sources, demographic goals tied to bonuses, and race or sex restricted mentoring and training programs were standard corporate practice just a few years ago.
Things are moving quickly, so what should employers do now?
This legal landscape and current environment is ever changing, so it's important to consult with counsel. But second, employers need to be really vigilant in their internal compliance review of their programs. In addition to looking internally, employers should look externally at their public-facing documents. Those are going to be subject to scrutiny. And lastly, employers should remember that these discrimination investigations can go back several years. So now, not later, is the time to conduct a records inventory and inspection of all their employment programs, past to present.
Thanks, Leah and Lori. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.